Welcome to the Privy DPDP Compliance Masterclass, an essential program for navigating India's Digital Personal Data Protection Act 2023. I'm Nikhil Jhanji, a certified DPO, and I'm thrilled to guide you through this transformative journey in data privacy and protection. At Privy, we've crafted this comprehensive course to provide you with deep insights and practical implementation guidance. Our curriculum goes beyond theory, offering an in-depth analysis of the Act's provisions, actionable strategies for enterprise-wide compliance, and real-world case studies and best practices. Engage with the material through video lectures delivered by industry experts, supplementary readings and resources, and interactive exercises to reinforce key concepts. Throughout the course, you'll assess your organization's current practices, explore the implications for your specific role and industry, and develop a tailored compliance roadmap. By virtue of doing this course, you now become part of a growing community of action takers who are making a difference in India's personal data protection landscape. Welcome to your learning journey with Privy. When we designed this course, we kept two things in mind. First, we wanted to cut through all the noise and offer a clear and comprehensive overview of what it means to bring the DPDP Act into the real world through implementation. Secondly, we wanted to go beyond the information that is already available out there and offer a pathway for action. If you are a privacy professional, a lawyer, a consultant in the privacy space, or a data protection officer, this course is for you. Let's look at all that we will cover in this course. In Chapter 2, we will explore the basics of the DPDP Act. Here, we will look at the scope and applicability of the Act and understand the differences between data fiduciaries, processors, and principals. We will learn about the rights of a data principal and the obligations of a data fiduciary. We will also explore how the DPDP Act differs from other laws worldwide. Along the way, we shall attempt to bust a few misconceptions and leave you with some thoughts to ponder over. In Chapter 3, we shall force you to think beyond the checkbox, as we will focus on the implementation of the DPDP Act via people, process, and technology. We will explore the gaps and myths around the legislative framework and explore how notices of the future should be designed. Chapter 4 will take us into how we can manage the rights of a data principal on one side and data processors on the other. This chapter will explore novel concepts like the consent lifecycle through the lens of both the fiduciary and the processor. Finally, in Chapter 5, we'll focus on data protection officers who are custodians of consent. We will look at all aspects of showcasing compliance with the Act. We will further go beyond compliance and explore ways in which earlier movers shall be able to set themselves apart from the competition in establishing trust with their user base. Ready to begin? Let's go. Chapter 2, Basics of the DPDP Act. The Digital Personal Data Protection Act 2023 is a landmark legislation in India that aims to protect the digital personal data of individuals while balancing the need for data processing for lawful purposes. This act establishes a comprehensive framework for data protection in the digital age, incorporating several key principles, including data minimization. The act emphasizes the principle of data minimization, which requires data fiduciaries to collect and process only the personal data necessary for specified purposes. This principle helps prevent excessive data collection and reduces the risk of data breaches. Consent. Consent is a cornerstone of the Act. Data fiduciaries must obtain free, specific, informed, unconditional, and unambiguous consent from the data principal before processing their personal data. The Act also provides for the right to withdraw consent, ensuring that individuals maintain control over their personal information. Accountability. The Act places significant emphasis on accountability. Data fiduciaries are responsible for complying with the Act's provisions, regardless of any agreements to the contrary. They must implement appropriate technical and organizational measures to ensure effective observance of the Act's provisions. Purpose limitation. Personal data can only be processed for lawful purposes and for the specified purpose for which consent has been obtained. This principle ensures that data is not used for purposes beyond what the data principal has agreed to. Data security. The Act mandates that data fiduciaries implement reasonable security safeguards to prevent personal data breaches. This principle aims to protect personal data from unauthorized access, disclosure, alteration, or destruction. Transparency. Data fiduciaries are required to provide clear and plain language notices to the data principals, informing them about the personal data being collected and the purpose of processing. This principle promotes transparency in data processing practices. Rights of the data principals. The Act grants several rights to the data principals, including the right to access information about their personal data, the right to correction and erasure, and the right to grievance redressal. These rights empower the data principals to have greater control over their personal data. Special provisions for children's data. The Act includes specific provisions for the protection of children's personal data, anybody below the age of 18 years of age, requiring verifiable parental consent and prohibiting certain practices like behavioral monitoring of children. By incorporating all of these principles, the DPDP Act aims to create a robust data protection framework that safeguards individuals' privacy while enabling the digital economy to thrive. The scope and applicability of the DPDP Act. The DPDP Act applies to Indian residents and businesses that collect the data of Indian residents. This is pretty straightforward. However, the Act also applies to non-citizens living in India whose data processing in connection with any activity related to offering of goods or services happens outside India. For example, a foreign national Sara living in India buys a product from an Indian website. Her data is processed through servers outside India, even though she's not a citizen. Since the data processing is related to a service offered in India, the DPDP Act applies here. The law aims to strike a balance between the recognized need to process personal data for various purposes and the individual's right to control and protect it. For example, an Indian food delivery app collects users' data for fulfilling orders but allows them to opt out of marketing. The DPDP Act ensures the company can process necessary data while giving users control over their privacy, balancing operational needs and individuals' rights. Much like a range of data privacy laws world over, the DPDP Act is extraterritorial. Thus, it applies to organizations that operate within and beyond India if they are offering goods or services to Indian citizens, and in doing so, are processing personal data. For example, a US-based streaming service offers subscription to Indian users. In doing so, it collects and processes personal data from its Indian customers, such as their contact and payment details. Even though the company operates outside India, the DPDP Act applies to it because it processes data to offer services to Indian citizens. While the company may process data based on legal grounds like service contracts, it must also obtain the user's consent for certain purposes such as marketing communications. The Act specifically excludes from its coverage any data processing done for purely personal or domestic purposes, and any personal data made public under a legal obligation from its scope and applicability. These exclusions ensure that the Act focuses on professional and commercial data processing activities. For example, data that you may have made public on your personal blog websites does not fall under the ambit of this Act. The trilogy: data fiduciaries, data processors, and the data principal. There are three key actors under the DPDP Act: the data principals, the data fiduciaries, and the data processors. The consent-taking process under the Act involves an organization, the data fiduciary, informing the individual, who's the data principal, about the personal information being collected and how it will be used. Consent must be clear, specific, and easily revocable, and can be managed through a consent management platform. that allows individuals to give or withdraw consent. A third-party service provider, a data processor, may handle personal data on behalf of the organization, but must comply with the organization's guideline to protect the data. Let's look at some of these key definitions. What is digital personal data? Any digital data about an individual that can identify them, whether collected in digital form or subsequently digitized. Think geolocation, IP addresses, personal health records, shopping patterns on a D2C app, ID documents, names, email addresses, and so on. Collected either digitally or even digitized post facto if the interaction has been in physical form. A data principal is the individual whose data is gathered and processed. They are effectively the data subject. A data fiduciary is an entity that either independently or in collaboration with others establishes the purpose and means for processing personal data. In effect, this entity is also referred to as a data controller in alternate regulations. Under the DPDP Act, a data fiduciary may be classified as a significant data fiduciary if their processing activities, such as the volume and sensitivity of personal data involved, and the impact on the rights of the data principal relates to larger social and national concerns such as India's sovereignty and integrity, electoral democracy, state security, and public order. If a data fiduciary is classified as an SDF, there are additional obligations imposed on them, such as the appointment of a data protection officer, appointment of an independent auditor to evaluate compliance with the Act, and carrying out of periodic data protection impact assessments. The government may impose restrictions on an SDF from time to time through other notifications. A data processor is responsible for processing digital personal data on behalf of a data fiduciary. Processing includes all kinds of activities across the data lifecycle, including collection, recording, and organization, to structuring, storing, and retrieval, and finally all the way to transmission, dissemination, or destruction. Broadly, there seem to be two categories of data processors, some which are non-customer facing and the others which face data principals directly. For example, card printing companies and logistics companies that deliver those cards, as well as marketing technology companies that send OTPs and email notifications. The latter processes personal data directly from the data principal, for example, a company that helps with video KYC or other white-labeled platforms. Now let's explore these three actors through the example of a co-branded credit card journey of a food delivery app, FDS, with Penguin Bank. This example will illustrate the flow of personal data from the food delivery app to the bank and eventually to data processors. Firstly, the FDS collects basic personal data including the full name, current address, phone number, email, and PAN card from the user. Here, the FDS is the data fiduciary and the user is the data principal. Next, the application is directed to the bank. The bank then collects additional personal data such as the Aadhaar card, proof of address, phone number, and work email. Here, the bank is the data fiduciary. Next, the personal data flows to the following people from the bank. The marketing tech provider collects phone numbers and email IDs to send OTPs and marketing content. The video KYC provider collects video footage, photographs, live location, identity documents to verify the customer's identity. The card printing provider receives all essential card details such as the CVV, card number, and expiry date to print the credit card. Finally, the logistics company collects personal data like name, phone number, and residential address to deliver the credit card to the data principal. All of these entities are data processors. In this example, the means and purposes were decided jointly by the food delivery service and Penguin Bank. Therefore, both of them may qualify as data fiduciaries. The categorization of data fiduciary and data processor, therefore, is non-trivial and ideal not to be thought of at the enterprise level, rather at the use case level. I urge you to replicate this exercise in your own spheres, whether it's an e-com app sign-up, an asset as wealth manager, gaming applications, or even physical-led sales flows. There are a few examples for you to explore in the post-chapter quiz. Apart from these entities, there are three more important personas that are major stakeholders as per the Act: the Data Protection Officer, the Data Protection Board, and the consent manager. A data protection officer or a DPO appointed by a significant data fiduciary ensures compliance with data protection laws. The DPO's responsibilities include overseeing data processing activities, conducting data protection impact assessments, and managing grievances related to personal data breaches. The DPO serves as the primary point of contact with the Data Protection Board, responds directly to a governing body of the organization, and ensures that data processing is aligned with legal requirements, especially regarding the rights of individuals who are the data principals. Additionally, the DPO ensures the organization implements appropriate safeguards to prevent data breaches. The Data Protection Board is an adjudicatory body established under the DPDP Act, enforces data protection laws. It monitors compliance, investigates complaints related to data breaches, and imposes penalties on violators. The DPB also issues directions to organizations to take corrective actions and handles disputes related to data protection, including mediation or formal proceedings. A consent manager under the DPDP Act is a registered intermediary that helps individuals manage their consent for data processing activities. Acting as a mediator between the data principal and the fiduciary, the consent manager enables individuals to give, manage, review, or withdraw their consent through a transparent, accessible, and interoperable platform. The key obligations of a consent manager are: number one, display consent notices that are easy to understand and allow users to make informed decisions about their data. And secondly, provide a mechanism for users to give or withdraw consent as easily it was provided, ensuring flexibility in managing their personal data. Consent managers must be registered with the Data Protection Board and follow the prescribed technical, operational, and financial guidelines. The role ensures that data principals have control over their personal data and that their consent is always clear and verifiable. Now let's look at the rights and duties of a data principal. As a data protection regime, the DPDP Act protects several rights of a data principal. Let's look at them one by one. First is the right to access their personal data. A data principal has the right to access their personal data held by data fiduciaries, including the source of the data, the purpose for which the data is being processed, as well as the categories of data recipients. If a data fiduciary processes email addresses alone, they must disclose the following things to the data principal: the email address they hold, the reason for processing it, how they got it, and with whom they will share this email address. Second, a data principal has the right to correct their personal data. If the personal data is inaccurate, incomplete, or incoherent, the data principal can ask for the data fiduciary to correct this data on their record. For example, if a data principal finds that their address is inaccurately recorded, they may ask for it to be updated. Thirdly, a data principal has the right to erasure of their personal data. A data principal is free to decide if they want to have their personal data erased, if they find that it is no longer necessary for the purpose for which it was collected or processed, and if they withdraw their consent to processing and collection. For example, if a data principal wants to have their data deleted from a small business whose newsletter they had subscribed to, they are free to request deletion and the data fiduciary must comply. A data principal also has the right to restrict the processing of personal data in particular circumstances. For instance, a data principal can choose to unsubscribe from a list that they are added to through a cold call, and a data fiduciary and processor must honor this decision. The right to object to personal processing of data for certain purposes is also one more right. They can raise an objection through the formal channels of the data fiduciary or through a legal route. For example, a data principal has the right to object to the processing of their data for direct marketing. Finally, the data principal also has the right to withdraw consent. At any point in time, the data principal can revoke the consent given to the data fiduciary, which makes it mandatory for the fiduciary to comply and stop collecting and processing data for that particular principal. Another approach a data principal has under the law to exercise their rights are through complaints to the Data Protection Board. A data principal who is not satisfied with the data fiduciary's response can file a complaint with the Data Protection Board of India. If the board finds that the data fiduciary has violated the law in any form, it may impose a penalty of up to 50 crores based on the nature of the violation. There also exist alternative mechanisms of dispute resolution via the appellate tribunal if required. Data principal also have a few duties over and above their rights, non-compliance with which may result in penalties of about 10,000 rupees for them as well. Accuracy, providing accurate, verifiable and up-to-date information, especially when requesting corrections or erasure. No impersonation, avoid impersonating others when sharing personal data. No false complaints, refrain from filing false or frivolous complaints. And finally, no information suppression. Do not withhold material information while providing personal data. Now let's focus on the key obligations of a data fiduciary. Under Section 4 of the DPDP Act, the data fiduciary has a primary responsibility to process data based on valid consent from the data principal. Data fiduciaries must process personal data based on valid consent from these principals strictly for the purposes specified. Section 5 of the DPDP Act requires a data fiduciary to alert the data principals about processing of their personal data. This means that a fiduciary must give the principal notice while asking for consent on the personal data being processed, the reason for processing, the information on the rights of the data principal, including submitting complaints to the Data Protection Board. This ensures that the data principals are fully informed of the collection of their personal data and the purpose for which their data is going to be used, and puts the responsibility on the data fiduciary to implement this. Section 6 explains the conditions under which a data fiduciary can request consent from a data principal. Any consent given must be free, transparent, specific, clear, informed, unconstrained, and unambiguous. It is essential for an individual to be able to expressly and voluntarily consent or choose not to consent to the collection and processing of their personal data. The fiduciaries are obliged to honor requests from the data principals to revoke or alter the legality of data processing that took place before the withdrawal. According to the DPDP Act, even if consent is revoked, a data fiduciary can continue to process personal data as necessary to complete a transaction or fulfill a contractual obligation, such as delivering goods already paid for. Data fiduciaries may deny certain rights, such as access, correction, or erasure, if the processing is required for compliance with a legal obligation, enforcement of legal claims, or for preventing, detecting, investigating, or prosecuting offenses. Additionally, these rights may be restricted if the data is needed to protect the sovereignty, integrity, or security of India as specified in the Act. Finally, as per Section 8 of the DPDP Act, data fiduciaries are required to notify both the Data Protection Board and the affected individuals in the event of a personal data breach. Non-compliance with respect to the obligations may lead to fines for the data fiduciary to the tune of 250 crores. Failing to implement security safeguards, there's fines of up to 250 crores. Not reporting a data breach to the board or the affected individuals, the penalties go up to about 200 crores. Mishandling children's data, that's another 200 crore fine. If you're a significant data fiduciary, failing to meet those additional obligations will cost you about 150 crores additional. For any other general violation, the fines go up to about 50 crores. The DPDP Act always gets compared to GDPR. In this chapter, we'll try to unearth key differences between GDPR and the DPDP Act. Firstly, let's look at the scope and applicability. GDPR applies to any organization processing the personal data of individuals within the EU, regardless of the organization's location. It covers both data controllers and processors with respect to fines, which may go up to about 20 million USD or a percentage of their global annual turnover. DPDPA, on the other hand, targets the protection of personal data in India, focusing on organizations collecting, processing, or storing data of Indian citizens. It enforces obligations on both domestic and foreign entities if they deal with Indian citizens' data, Here, the burden of proof lies with the data fiduciary alone. The legal basis for processing. In GDPR, enterprises require at least one lawful basis for processing, such as consent, contractual necessity, legal obligation, vital interests, public tasks, or legitimate interests. Whereas on DPDPA, there is a strong emphasis on consent as the primary lawful basis. The Act goes further by insisting that the notices be provided in all languages listed in the 8th schedule of the Indian Constitution, including English, ensuring accessibility for India's diverse population. On data subject rights, GDPR offers a broad range of rights including access, rectification, the right to be forgotten, restriction of processing, portability, and objection to data processing. DPDPA has similar rights as GDPR but adds the ability for individuals to nominate other persons to exercise their rights in case of death or incapacity. On data protection measures, GDPR requires organizations to implement appropriate technical and organizational measures to ensure data security, including data encryption, access controls, regular security assessments, and reporting of data breaches within 72 hours. DPDP, on the other hand, mandates strong data protection measures, including the appointment of a DPO, conducting data protection impact assessments, and implementing data security frameworks, including the reporting of data breaches. On cross-border flows, GDPR has strict requirements for transferring data outside the EU, including adequacy decisions, SCCs or standard contractual clauses, and BCRs or binding corporate rules. DPDPA, cross-border transfers are allowed, but adequate safeguards must be in place and consent from data subjects is required. A negative list approach is taken by DPDPA. In Chapter 2, we covered the fundamental aspects of the DPDP Act, a landmark legislation in India aimed at safeguarding digital personal data. We explored key principles such as data minimization, consent, accountability, and purpose limitation. The chapter introduced the trilogy of key actors, data principals, data fiduciaries, and data processors, explaining their roles and responsibilities. We discussed the Act's scope and applicability, including its extraterritorial nature. The rights and duties of data principals were outlined, including access, correction, and erasure of personal data. We also examined the key obligations of a data fiduciary. The chapter concluded with a comparison between the DPDP Act and GDPR, highlighting similarities and differences. To reinforce your understanding of this critical concept, we encourage you to take the post-chapter quiz and test your knowledge of this important legislation. In this chapter, let's try orchestrating compliance at enterprise scale. Getting started with DPDP compliance, let's first try to bust some myths that are out there. The implementation for DPDP Act compliance is critical for organizations to avoid imminent hefty penalties, mitigate the risk of data breaches, demonstrate legal compliance, and build trust with data principals. To effectively address this challenge, it's prudent to divide the problem into two categories: stock, which is existing data and processes, and flow, new data and ongoing operations. The DPDP Act mandates that organizations obtain clear, informed consent from existing users for data processing, along with the provision of notices that detail how the data will be used, users' rights, and options for consent revocation. If previous consent doesn't meet these standards, fresh consent may be required. However, we believe that the government will provide additional timelines for compliance with existing data, and thus immediate data discovery for existing users may not be viewed as a first step, while definitely a logical parallel exercise. Prioritizing new data and ongoing operations under the Act ensures immediate compliance, as it allows organizations to integrate consent and data management processes from the start, reducing legal risks. It's easier to implement standardized, efficient workflows for new data compared to the complex audits required for existing customer details. This approach is operationally efficient, ensuring business continuity while allowing companies to gradually handle legacy data compliance in a phased manner, aligning with future regulatory timelines. It is crucial to understand that moving the needle meaningfully on compliance shall need work across people, process, and technology. Starting your compliance glide path with a thorough gap analysis can be incredibly fruitful for your organization. But what does this entail? A gap analysis involves evaluating your current practices against DPDP standards, helping you identify areas that need improvement. Let's break down the key steps. Step number 1 is mapping personal information flows across digital native experiences like apps, website, or product sign-up flows, as well as physical flows which are human-centric or salespeople-led. Step number 2 is analyzing policies and procedures, including reviewing your privacy policy, your cookie policy, as well as procedures for handling data principal requests. Step 3 is data minimization and processing objectives. A critical milestone in your compliance journey is adopting these minimization practices. This means collecting only necessary data and documenting clear objectives for data processing. This step not only aids compliance but also builds trust with your data principles. Lastly, evaluating staff awareness and training needs. How aware is your staff for data protection principles, and what training needs exist across the different departments? Identifying these gaps will help you develop a comprehensive training program. By following these steps in your gap analysis, you'll gain a clear picture of where your organization stands and what needs to be done to achieve DPDP Act compliance. Do check out our Ready Reckoner on assessing your organization's current state in the course resources at the end of this chapter. Now let's look at getting your privacy notices right, thinking beyond the checkbox. Data fiduciaries must obtain free, specific, informed, unconditional, and unambiguous consent with a clear affirmative action from data principals before processing their personal data. We've been to multiple client calls where the most obvious questions that keep getting asked are: does a compliant notice just mean additional checkboxes and more user friction? Can I continue to take consent with a revamped privacy policy document and the same catch-all consent? Can I skip taking consent for purposes that may be required by alternative laws? The answers to all of these is a big no. The mantra to DPDP compliant notices is being able to capture and maintain consent at the granular hierarchy of PII elements times the processing purpose. This means that even if we are collecting the same mobile number for 3 separate purposes, sending execution OTPs, marketing and promotions, and even training a machine learning model, all of these 3 would require 3 granular consents. A precursor to getting the privacy notice right is establishing an enterprise-wide purpose taxonomy. The real magic lies in making the to-be state of the consent artifact superimpose seamlessly onto your enterprise business landscape. Imagine a future where the organization's privacy policy can get deconstructed into a set of compliant notices as the data principal interacts with the organization's landscape. This potentially means the need for a different notice for employees, a different one for each product or service flow across touchpoints and across various points of time. A purpose taxonomy simplifies the entire consent management process by clearly defining and streamlining the identification of data processing purposes. This approach makes it easier for organizations to collect, manage, and align consents with specific purposes, ensuring that both DPDP compliance and data principal rights are handled efficiently. This is also referred to as ROPA, or Record of Processing Activities, in other global privacy laws. The promises made in the notice must be fulfilled by the organization and not just by lawyers or privacy professionals. The responsibilities under the DPDP Act are not exclusive to lawyers and privacy professionals alone, but to every actor involved in the organizational setup that collects and processes data. This means that every item named in the notice binds the data fiduciaries and processors alike, and they are expected to adhere to it. Accordingly, data cannot be collected or processed for reasons and grounds other than those named, and consent once given specifically to one purpose must be respected and not expanded to cover other purposes for data processing. Let's look at what DPDP compliant notices could look like. The notice to seek consent under the DPDP Act is a crucial component of the consent management process, ensuring that data principals are fully informed before their personal data is collected or processed. This notice must be presented in 22 languages as per Schedule 8 as an electronic document, independent and easily understandable, allowing the data principals to store it for future reference. The notice should clearly describe the personal data that is being collected, specific purposes for processing, and affirm that only the necessary data will be processed for those purposes. It also outlines the duration for which the data will be processed and retained. Additionally, the notice must inform the data principal of their rights, including the right to withdraw consent at any time, and provide clear instructions on how to exercise these rights or raise grievances. This approach ensures transparency, empowering data principals to make informed decisions about their personal data and fostering trust between them and the data fiduciary. The notice of processing done is required when a data principal has previously given consent for data before the Act's commencement. Example, all current or past users of the app or product, or all existing customers of a loyalty program, or even all employees of your organization. This notice must be issued by the data fiduciary in a similar manner to the notice to seek consent as soon as possible. It may be prudent to attack this stock problem in a manner that is aligned to the compliance goals of the organization. A few approaches include iteratively serving these notices based on customer cohorts and delivering them through in-app, email, or alternative communication channels. After all this theory, Privy now offers you 3 actionables to help you design the perfect notice for your digital journeys. Inspect AI. Privy Inspect AI is an advanced compliance copilot designed to empower data protection officers by automating compliance gap assessments for digital journeys. It helps DPOs ensure compliance across the software development lifecycle by identifying personal data fields, processing purposes, and analyzing privacy policies for non-compliance with the DPDP Act. Additionally, it enables the creation of DPDP compliant notices, giving DPOs a head start in their compliance efforts and helping them maintain compliance standards across the organization. Privy has collaborated with DSCI, Data Security Council of India, to release the industry's first DPDP compliant notice generator. This nifty tool allows you to envision what compliant notices could look like, custom to your digital flows and prevalent regulations. Do check this out in the chapter resources. We also share with you the Holy Grail, a purpose taxonomy template to help automate your notice design. This novel concept of designing notices as an aggregation of reusable purpose blocks is the key differentiator that could streamline notice design and management in your organizations. Consent lifecycle management. Effective notice design should be viewed as an ongoing process rather than a one-time event. Notices should evolve and adapt over time to remain relevant and useful to the data principals. This reframing emphasizes the dynamic nature of notices and the need for continuous improvement in how organizations communicate with individuals about data processing. It suggests that notices should be regularly reviewed and updated to reflect changes in data practices, user needs, and regulatory requirements. Mapping the consent lifecycle to the data lifecycle is crucial. When both are aligned, every stage of data handling is governed by clear, valid, and actionable consent. To effectively choreograph this alignment, you should focus on all of the 3 actions: consent collection, consent renewal, and consent revocation. To enable compliant notice-led interactions, organizations must think about integrations across two key dimensions. Upstream integrations involves collecting personal data with the data principal's participation. It comprises customer-facing data processors, API, web redirection, and SDKs, amongst other things. Think about the modality in which the notice shall be spun up during a compliant interaction, whether the notice shall be preceding the n-step flow or be baked into the digital journey. Think of app signups, lending flows, and retail D2C flows here. The second dimension is downstream integrations. This involves sharing data with data processors. The data can fall into two categories, where only authorized personnel have access, and two, something that is fragmented across multiple departments, making compliance with regulations difficult. Regardless, having a single source of truth for consents is essential for the enterprise to ensure proper management and security of sensitive information. Think about how downstream applications within your organization or external data processors may consume the latest status of the consent to take actions. For example, how does my marketing automation system know whether from the millions of email IDs on which it is about to orchestrate an email campaign, how many does it have the consent to do so? Implementing effective notices requires a cross-functional approach, integrating the expertise of privacy professionals, compliance officers, and technology and product teams. This collaborative effort should be supported by streamlined processes to ensure cohesive and compliant notice design. This reframing emphasizes the need for interdisciplinary collaboration, the specific roles involved, privacy, compliance, technology, and product, the importance of process redesign to facilitate this collaboration, and the ultimate goal of creating effective notices through this integrated approach. Technology considerations for consent compliance. When implementing systems to manage consent and demonstrate compliance, two key technological aspects to consider are immutability and comprehensive audit trails. These features help ensure the integrity and traceability of consent artifacts. Immutability refers to the inability to alter or delete records once they are created. For consent artifacts, immutability is crucial for preserving the original state of consent given by individuals, preventing unauthorized modification that could compromise compliance, and providing a verifiable historical record for audits. To achieve immutability, the following approaches could be considered. Leveraging blockchain technology such as distributed ledger systems to create tamper-proof records of consent transactions. Worm or write-once, read-many storage using specialized storage systems that prevent data modification after initial writing. Finally, cryptographic hashing, generating unique hash values for consent records to detect any alterations. Comprehensive audit trails provide a chronological record of all consent-related activities. Key aspects include capturing all the consent events, collection, modification, withdrawal, etc., recording metadata like timestamps, user IDs, IP addresses, and ensuring completeness, logging both successful and failed operations. Implementing robust audit trails includes centralized logging for aggregating consent logs from all your relevant systems, real-time monitoring to enable prompt detection of anomalies or compliance issues, and tamper-evident logs using cryptographic techniques to prevent log manipulation. The gold standard in India with respect to both these requirements is a reference to MeitY's electronic consent artifact, with close ties to DPDP, which is the Data Empowerment and Protection Architecture. Electronic consent artifacts shall additionally need to be constructed in a manner that they qualify as evidence in front of an adjudicatory body like the Data Protection Board. This is allied to the erstwhile Indian Evidence Act, Section 65 A and B, newly overridden by the Bharatiya Saksha Adhyan 2023, Section 61 to 63. By combining immutable storage with comprehensive audit trails, organizations can create a robust technological foundation for demonstrating consent compliance. This approach provides transparency, accountability, and verifiability throughout the consent lifecycle. Let's look at DPDP compliance implementations at scale a little further. We've heard about DSARs in the privacy world. Given that our Act refers to data subjects as data principals, let's dive into understanding DPARs or data principal access requests. The DPAR mechanism, as outlined in the DPDP Act, empowers individuals to request access, review, update, or delete their personal data held by data fiduciaries. The process emphasizes transparency and control, ensuring data principals can easily manage their personal data. Individuals can submit these requests via a DPAR portal or through a consent manager. Upon receiving a request, the data fiduciary must respond promptly, providing either consent-related information or personal data depending upon the request type. For consent-related information, the fiduciary retrieves such information using consent artifacts that contain details about the consent provided by the data principal, ensuring that all requests concerning consent management are accurately addressed. For personal data requests, such as requests for data updates, deletions, or review, the fiduciary would need to respond based on the personal data stored and shared across various data processors, potentially with the help of data flow diagrams. The fiduciary is responsible for ensuring that actions taken are transparent and compliant within the timelines and requirements of the DPDP Act, ultimately maintaining trust and accountability in their data processing activities. Data fiduciaries are required to maintain transparency, comply with legal timelines, and ensure the accuracy of the data processing. The DPAR system ensures that organizations follow the principles of accountability, trust, and fairness in handling personal data, giving individuals more control over how their information is used. Now let's look at a few DPDPA specific nuances while designing the ideal DPAR flow at your organizations. Robust authentication. Ensuring a strong authentication process is critical for verifying the identity of the data principal making the request. For example, when an individual requests access to their personal data, concepts like multi-factor authentication or UIDI-based verification can prevent unauthorized access. This step mitigates the risks of impersonation and reduces the chance of sensitive data falling into the wrong hands, safeguarding against fraud. Navigating DPDPA and other regulatory overlaps. When working within the regulated industries like banking or insurance, organizations may encounter overlapping or conflicting rules from industry regulators such as RBI, SEBI, and IRDA. For example, DPDPA might mandate data deletion post a deletion request being received from a data principal, but RBI regulations might mandate retaining transaction data for 10 years even after a customer relationship has ended. Balancing these requirements is key to ensuring full regulatory compliance. Integration with existing grievance redressal mechanisms. Many organizations today already have a grievance redressal and case management framework in place, especially for customer service and complaint handling. Instead of building an entirely new system, it's beneficial to consider how the DPAR flow could integrate with and enhance existing grievance mechanisms. This approach leverages the current systems while enhancing accessibility and efficiency for data-related requests. Technology and process automation. Technology can play a significant role in streamlining DPAR requests, enabling automation and tracking. Automated workflows, data masking, and secure portals for submission and response can enhance both efficiency and security. This approach reduces manual handling, minimizes errors, and ensures that responses are timely, which is essential for meeting regulatory timelines. Automated documentation with clear logs of actions taken ensures accountability and enables thorough audits. Let's dive into the world of PIAs and DPIAs. But what is a PIA or a DPIA, and what's the difference between these two? A PIA, or a privacy impact assessment, helps organizations identify and manage privacy risks in their data processing activities. The main goal of the PIA is to evaluate the impact of data processing on the individual's privacy and to ensure compliance with privacy laws and best practices. A DPIA, on the other hand, is more specific assessment required by data protection laws like the GDPR and DPDP for processing activities that are likely to pose a high risk to the individual's privacy. The DPIA's goal is to assess and minimize the risks posed to the individual's rights and freedom due to specific high-risk data processing activities. DPIAs must be conducted where there is a significant risk to the rights and freedoms of individuals and results are recorded in a specific format. Most organizations choose to implement a workflow that contains an initial risk assessment or threshold questionnaire that is lightweight and can be performed first to understand the overall risk and determine if a DPIA is actually required. Implementing DPIAs. Once the risk analysis of the threshold questionnaire confirms that DPI is necessary, the following steps could be followed. Step 1. Describe the processing activity and document. When describing a data processing activity in a DPIA, start by identifying what personal data is collected, such as names and contact details. Clearly outline the purpose of data collection, like user authentication, personalization, and specify who has access to the data and where it will be securely stored. Document any data sharing with third parties and ensure they have robust data protection measures in place. Define the context and scope of processing, like using purchase history for personalized recommendations, and state the objectives such as improving customer experience or meeting legal requirements. Determine how long the data will be retained based on regulatory and business needs. This clear description forms the basis for assessing risks and ensuring compliance. Step 2. Analyze risks from the data principal's perspective. When analyzing risks from the data principal's side in a DPIA, the primary goal is to understand how the data processing could affect individuals' rights and freedoms. This involves examining all potential impacts, both tangible and intangible, that may arise from data collection, storage, or sharing. Privacy risks, data breaches, identity theft, financial frauds, reputational impact are few of the critical parameters to consider. Let's analyze this with an example. Consider a fitness tracking app that collects location data. If this data is mishandled or accessed by unauthorized parties, it could reveal the user's daily routine and frequented locations, posing a risk to their physical safety and personal privacy. Step 3. Reference EU supervisory authority lists versus DPDP requirements. The EU has guidelines on specific processing activities that require DPIAs. Organizations should align their assessments with these lists to ensure they meet jurisdictional standards. The DPDPA requires this as a key obligation of significant data fiduciaries. If a DPIA reveals risks that cannot be mitigated to an acceptable level, consultation with the relevant supervisory or regulatory authority may be required. This involves sending the DPIA to the authority, which may request further information or corrective actions to ensure data protection compliance. In summary, a DPIA should include 6 essential components to ensure compliance and data protection. First up, describe the processing activity, detailing the types, volume, and handling of personal data. Second, outline the purpose of data processing, including its legal basis. Third, document the lawfulness of processing, ensuring it aligns with privacy principles like data minimization. Fourth, identify risks to the individual's rights and freedom, considering the nature and scope of processing. 5. List measures to mitigate identified risks, such as security safeguards. And finally, assess any residual risks after implementing these measures to confirm they sufficiently protect personal data. Operationalizing privacy by design involves integrating privacy safeguards into every stage of product and process development. From the outset, consider privacy implications to ensure that personal data is handled securely and in compliance with legal requirements. By embedding these considerations early, organizations can proactively address potential privacy risks rather than reacting to issues after they arise. This approach also involves minimizing data collection, restricting access and implementing strong data protection measures tailored to the specific use case. Regularly reassess DPIAs. Revisit DPIAs periodically, especially after significant changes to data processing activities or when new risks arise. Continuous updates help maintain relevance and effectiveness in protecting data rights. IDfy has thoroughly examined the compliance requirements for conducting DPIAs under global privacy regimes and offers a DPIA module catering to the specific requirements of the DPDP Act in India. Do check it out in the chapter resources section. In chapter 4, we covered the critical aspects of orchestrating DPDP compliance at enterprise scale. We began by exploring the implementation of Data Principal Access Requests or DPARs, which empower individuals to request, access, review and update their personal data held by data fiduciaries. We then delved into the world of PIAs and DPIAs or Data Protection Impact Assessments. Throughout the chapter, we provided practical insights and tools to help organizations implement these crucial compliance measures effectively. We encourage you to test your understanding of these concepts through the post-chapter quiz, reinforcing the importance of these practices in orchestrating DPDP compliance at enterprise scale. In this last chapter, let's look at how important the role of a DPO is, the Data Protection Officer, the Consent Custodian. The DPO plays a critical role in an enterprise's journey to compliance with the Digital Personal Data Protection Act. A modern DPO's core responsibilities include compliance oversight to ensure that the organization adheres to all requirements of the DPDP Act. This includes monitoring data handling practices, ensuring lawful data collection and processing, and overseeing data principal rights. Risk assessment and mitigation. The DPO also helps identify and mitigate privacy risks before they escalate, protecting the organization from reputational damage, legal action, and the potential loss of business. This includes serving as the point of contact for grievance redressal mechanisms and overseeing the management of risks associated with third-party vendors and data processors, which may include ensuring that appropriate contractual agreements are in place, conducting due diligence, and monitoring compliance of these external entities. A DPO's position holds significant strategic importance. Acting as the primary liaison between organizations, data principals, and regulatory authorities including the DPB, the DPO is instrumental in formulating and implementing the organization's data protection policies and procedures. A key responsibility of the DPO is to cultivate a privacy-aware culture within the organization through training sessions and awareness programs. Finally, the DPO oversees periodic data protection impact assessments and audits to ensure ongoing compliance. From an organizational positioning perspective, the DPO should operate independently within the organization, reporting directly to the highest level of management, a board or equivalent. The DPO provides strategic and valuable insights to the board or management on data governance and privacy matters. This role requires working across various departments to ensure comprehensive data protection practices. Hence, the DPO plays a crucial role in not only ensuring compliance within the DPDP Act, but also in fostering a culture of data protection and privacy within the organization. This in turn helps build trust with data principals and positions the enterprise favorably in an increasingly data-driven business landscape. The modern enterprise data protection officer faces several challenges in ensuring compliance with DPDPA. Firstly, there's complexity of compliance. The DPDPA introduces comprehensive data protection requirements that can be complex to implement across large enterprises. DPOs must ensure proper data mapping, adherence to consent rules, and implementation of security measures. Evolving regulations. As privacy laws continue to change, DPOs must stay updated and adapt organizational practices accordingly. This requires constant vigilance and agility. Balancing business and privacy. DPOs often face the challenge of balancing organizational goals with stringent privacy requirements. This can create tension between different departments. Managing global compliance. For multinational organizations, DPOs must ensure compliance with DPDP Act while also adhering to international regulations and guidelines. Build versus buy on technology. Many organizations lack the necessary technological infrastructure to implement DPDP requirements effectively. Balancing the cost of compliance with the possibilities of fines and damage from the lens of build versus buy shall be crucial for the DPO and the DPDP working group. By leveraging a consent governance platform like Privy by IDfy, DPOs can more effectively navigate the complexities of DPDP compliance, freeing up time and resources to focus on strategic privacy initiatives, balancing business needs with regulatory requirements. Let's look at how DPOs can centrally manage third-party risks. Data sharing agreements are the foundation of your relationship with processors. These agreements should clearly outline the scope and the purpose of data processing, security measures to be implemented, confidentiality obligations, procedures for handling data principal requests, and incident reporting protocols. For instance, if you're working with a marketing analytics firm, your data sharing agreement should specify exactly what customer data they can access, how long they'll use it, and how they'll protect it. It's essential to include liability and indemnification clauses to protect your organization. If you're dealing with cross-border transfers, such as using a US-based cloud service provider, ensure your DSAs address the specific requirements outlined in the DPDP Act. Moving to technical aspects, focusing on mapping data flows to and from data processors, implementing robust access control mechanisms, leveraging PETs or privacy-enhancing tech for data in rest and transit, establishing a framework for secure data deletion, and finally setting up a comprehensive audit, logging and monitoring system. For example, if you're working with a payment gateway, you'll need to map how customer financial data flows from your system to theirs, ensuring it's encrypted and has a clear process for deleting this when it's no longer needed. Don't forget about incident response and breach notification procedures. Your processors should be well versed in these protocols to ensure timely and efficient responses. On the non-technical side, conducting thorough due diligence when selecting vendors cannot be overstated. Implement ongoing compliance monitoring and regular training programs for processor staff is crucial too. Clear communication channels are vital, as is having a strategy for managing sub-processors. Lastly, develop a robust audit program that includes both on-site and remote audits. Key areas to evaluate include data handling practices, security measures, compliance with the DSA terms, and incident response readiness. With this strategy, you shall be empowered to showcase compliance with DPDP Act to either the Data Protection Board or an auditor, both of which may fall as a recurring activity as part of your role as a significant data fiduciary. As we conclude this compliance masterclass, we wanted to leave you with a tangible plan to move the compliance needle meaningfully in your respective enterprises. Let's outline a comprehensive strategy for the enterprise across people, process, and technology levers while addressing both flow and stock challenges. Let's first talk about people. Leadership engagement is crucial. You'll need to secure top management buy-in and establish a cross-functional privacy steering committee. Next, focusing on training and awareness by developing role-based training programs and conducting regular privacy awareness sessions. To drive a cultural shift, you'll need to foster a privacy by design mindset and encourage data minimization practices. Moving on to the process. Starting off with a gap assessment using assessment automation tools for doing quick assessments and identifying compliance gap in your current practices may be useful. On policy development, creating comprehensive privacy notices and developing standard operating procedures for data handling will be useful. Implementing a robust consent governance solution by setting up a system for collection and management of consent, ensuring transparency in data usage purposes. Don't forget about the rights of the data principals by establishing procedures for handling requests and setting up grievance redressal mechanisms. Technology plays a crucial role too. Implementing a privacy and consent governance platform like Privy helps you integrate consent management, data discovery, and DPIA modules. On data discovery and classification, implementing automated tools as well as classifying personal data based on sensitivity and purpose shall be useful. On orchestrating consent notices, creating a centralized consent artifact repository, and enabling multilingual consent notices are the way ahead. Finally, don't forget about cookie management by implementing an appropriate cookie banner on your websites and ensuring compliance with the regulations. A key strategy is addressing both flow and stock problems in parallel. For immediate flow, prioritizing the top digital customer journeys and implementing compliant consent collection, as well as setting up real-time audit trails is crucial. For ongoing stock management, conducting a comprehensive data inventory, mapping existing data to purposes and legal bases, and implementing data retention and deletion policies. Let's look at a sample implementation roadmap. In the first few months, conducting a gap assessment, developing an organization-wide purpose taxonomy, implementing consent notices for the priority journeys, and setting up a cookie banner. This will help us achieve base compliance very quickly. From months 5 through 8, we could expand the compliance to more customer journeys across various kinds of data principals, implement data principal rights management module, and begin our data discovery for the existing data. Months 9 onwards, we would implement continuous monitoring and refine our data processor management strategies. Remember these key implementation principles. Focus on quick wins and immediate compliance. Tailor your approach to your operating model. Future-proof your compliance efforts and stay adaptable to regulatory changes. Remember, the DPDP Act compliance is an ongoing journey. By focusing on people, process, and technology, you'll build a robust privacy framework that ensures compliance and builds customer trust. Start your transformation today with a comprehensive privacy suite like Privy and stay ahead of regulatory changes while creating a competitive advantage for your organization. Good luck on your compliance journey.